Let me go ahead and introduce our moderator and chair of this panel, Christopher Joyner. He is a PhD doctor and professor from Georgetown and director of Georgetown's Institute for International Law and Politics. He is probably the most prolific scholar in the room, maybe in the country, with 300 articles to his credit and 15 books, including texts that are relevant to this discussion on the United Nations and the International Court of Justice. And he is the perfect moderator for our final panel.
Have fun, he says. Thank you very much, Michael. Very generous introduction. I was going to begin my comments with a little story about Ben Ferencz, but I see that he's left. But let me begin with it anyway, because I think it sets the tone. I started going to the American Society of International Law meetings in 1971 as a graduate student. And I was there every meeting for 24 years straight. Sort of a record, I guess, but I didn't even get a pin. The point of all this was, at every human rights panel, Benjamin Ferencz would stand up and begin his comments with, I was a former prosecutor at the Nuremberg Tribunal. And he made the plea at every human rights session that genocide should be considered a gross violation of human rights that needed to be prosecuted much more actively than it was being. Of course, nothing happened between 1947, Tokyo War Crimes Tribunals, and the early 1990s. But Ben's plea has been finally heard, and it is astounding that in the last 17 years or so, so many new institutions have been created, such publicity has been given to this crime of genocide, and this important conference today, I think, mirrors that reality. I should also take the time now to thank, on my behalf, but I'm sure all of our behalves, Michael Scharf for organizing this, and Nancy Platt and the other organizers for making it happen. It's been a wonderful day, and I genuinely appreciate it. Let me begin by saying that this is a special format. It is a roundtable. It is a conversation, a dialogue. It is not a crossfire, and it is not a reading of papers formally. Let me also begin by introducing our panelists. I will try to do this succinctly, but it's hard because they're all very distinguished international lawyers in their own right. Mark Drummel, as he reminded me earlier today, is a chaired professor of international law. He's at Washington Lee College of Law, and he's the class of 1975. He's the class of 1975 alumni professor and director of Transnational Law Institute at WNL. He is a Canadian national, but we'll forgive him for that. His education's at McGill, University of Toronto. Then he saw the light and went to Columbia, where he earned his LLM and JSC degrees. And as you no doubt remember, he is the winner of this year's International Association of Criminal Law Book of the Year Award for his outstanding volume, Atrocity, Punishment, and International Law. Next to Mark is Michael Pyle, Assistant Dean for International Programs at Washington University School of Law. He is also the Executive Director of the Whitney R. Harris Institute for Global Legal Studies. He earned his JD degree from Cornell Law School and previously taught European Union law at DePaul University College of Law, where he met, and I'm sure was influenced by, the godfather of international criminal law, Sharif Bassioni. Next to Michael is John Quigley. John Quigley is also a chaired professor at Ohio State University. I'm not a chaired professor, that's why I'm making a big deal out of this. He is the President's Club Professor at International Law at Moritz College of Law at Ohio State. John is an incredibly prolific author, numerous articles, numerous books. Among his books are a number that are particularly relevant for this discussion. One is The Ruses for War, American Intervention Since World War II. That came out this year. And the second one I think that's especially relevant is his book, The Genocide Convention, an International Law Analysis, which came out last year, 2006. Unlike many international law professors, he writes a lot of books, which is, I think, very impressive. And finally, but certainly no doubt not least, Layla Sadat, who's also a chaired professor of international law. The Henry Obership Professor of Law at Washington University School of Law. She has incredible expertise on the International Criminal Court and was very active working with Sharif Bassioni and Michael Scharf in the discussions leading up to the 1998 Rome Statute negotiations. She earned her J.D. at Tulane with the highest honors. She earned her LLM degrees from Columbia University and the University of Paris at Sorbonne. And she's the author of a very impressive monograph entitled The International Criminal Court and the Transformation of International Law. So we have a very distinguished group of panel, nearly all of whom are chaired professors of international law. And again, this will be a conversation. Let me begin by setting the context very briefly.
Yeah.
That's not funny.
Yeah.
That's not funny. There have been 100 new chairs created at Georgetown University in the last 5 years. None for an international lawyer in the Department of Government. Okay. The context is really the International Court of Justice. As I mentioned about Ben Ferencz, when he started delivering his plea before the American Society, there was no institution really who was going to take up the crime of genocide. Now we have institutions going from the International Criminal Court for Bosnia all the way up to the International Court of Justice. One of the questions that this panel has to address is, what is the effectiveness of those decisions and that work, and what significance does it hold for genocide as a crime under international law? To set the context and to remind you, the International Court of Justice acts as a world court. It has dual jurisdiction. On the one hand, it decides in accordance with international law disputes of a legal nature that are submitted to it by states. This is the so-called jurisdiction in contentious cases. And on the other hand, it gives advisory opinions to legal questions at the request of organs of the United Nations or specialized agencies. And this is the advisory jurisdiction. To remind you again, only states may apply to and appear before the International Court of Justice. International organizations, other collectivities, and private persons are not permitted to institute proceedings before the court. So, where does the International Court of Justice fit into this discussion? In February of 2007, the ICJ handed down a long-awaited decision on the case of Serbia and whether or not it was in violation of the crime of genocide in Bosnia. The court found that the Srebrenica massacre was indeed an act of genocide, but there was not enough evidence to show that the Bosnian Serb fighters had carried out the killings under the authority and order of Serbian authorities. The court also said that the Serbian authorities had not met their obligation under international law to prevent and punish genocide. Why? Because they had failed to use their influence over the Bosnian Serb forces to try and prevent them from committing a predictable massacre. And they also failed to take steps to punish those individuals responsible or to hand them over to the Yugoslav War Crimes Tribunal. The basis for the jurisdiction on the ICJ's case will be discussed by this panel, but it has largely to do with the Genocide Convention and whether or not that convention is adequate for the ICJ to act. What I have done is to put together a series of questions that hopefully will foster a dialogue amongst the panel. And let me begin with one that's central to the whole discussion we're now addressing. is genocide perpetrated by a state subject to the ICJ's jurisdiction? And if so, why? And if not, why not? I'll ask anybody in the panel. John, you want to start?
Well, the Genocide Convention is written like a criminal provision. I mean, it has an act, it has the mens rea. All during the drafting, the British government and the Belgian government tried to insert provisions that would make it clear that the convention also prohibited perpetration by a state of genocide. That was resisted by others who were confused by it because the text was being drafted like a criminal law. And so many responded by saying, well, we don't understand what this would mean. And Britain responded by saying, well, what it would mean is that the state would bear responsibility in the way states normally bear responsibility to other states. You're not calling the state a criminal, but it would bear liability under international law. It would be an internationally wrongful act on the part of the state, to use the more recent language used in the draft articles on state responsibility. Finally, at the last hour, when they were discussing Article 9, the submissions clause to the International Court of Justice, Britain and Belgium prevailed in getting language to their liking on this issue, so that the submissions clause says not simply that disputes under the convention will go to the International Court of Justice, but says including the responsibility of a state for genocide. And that has been read now by the International Court of Justice to provide for submission to the International Court of Justice against a state which is charged by the plaintiff state with perpetration. That was objected to by some judges on the court. They didn't think that that was an appropriate reading. And it is something that I think is open to discussion, although I think the court got it right. It's even a bit clear in the Russian version of Article 9 because it says, instead of saying for genocide, it says for the perpetration of genocide, which makes it a little bit clear that what's being talked about is perpetration by a state. But the majority, and this is now in the 1996 decision of the court on jurisdictional issues, the court said that it's implicit in the idea of the obligation to prevent and punish in Article 1 that you can't do it yourself. That if you do it yourself, you would ipso facto be failing to prevent and punish.
Michael, you want to add something to that?
Well, I mean, and obviously counsel for Yugoslavia didn't agree with that position, and they argued that the obligation to prevent and punish means just that, that this was, in essence, looking at the definition articles 2 and 3, this set out a criminal definition, which is to say individual liability, and that Article 9, and that the only affirmative obligation put upon states was this obligation to prevent and punish. The Russian judge, in an additional declaration, picks up some of this in his discussion of the competence of the court. This is the February decision. But by and large, the court rejected this argument.
Well,
the only thing I might add to that, I agree with John that it's probably the right answer, and I don't find it a terribly surprising answer, actually. Given the text of the convention, you wouldn't even need to go really to the Tribunal. It seems pretty clear. But I think it does raise the interesting issue. If it's contemplated that you can have a civil case, that is a state responsibility case, involving the Genocide Convention, does it follow that the state responsibility case has to track the criminal cases, individual criminal cases? And I made the argument, and I haven't thought this through completely, but it seems to me in the state responsibility context that you could have a very different kind of case than you get when you're looking at the particular liability of a particular person for potentially having committed or not an act of genocide. And I think that's where I feel the ICJ maybe didn't do very much justice to the case, but we'll save that discussion.
Mike, you're not, Mark, you're nodding yes to a lot of things.
Well, I think, okay, so this is my take. This decision has been subject to a lot of criticism. It's anemic, it's weak. We heard from Bill this morning that it's not really something that, we should get terribly excited about. But I think as a point of law, one thing that's interesting to me pushes Layla's point a little bit further, which is the following. The ICJ clearly held that the emergence of individual criminal responsibility in international law that we herald as being the output of the work of all of these tribunals we're so familiar with, that emergence has not completely squeezed out or supplanted the idea of collective civil or state responsibility for genocide, at least not expressively in terms of verdict or judgment. We can talk about damages afterwards, and that just didn't happen. But I actually think that's a fairly important point that hasn't received a lot of attention, and it's not every judge on the ICJ that felt that way, but the majority did. And for those of us, such as myself, who believe there is an important role for much more than just the criminal law in thinking about atrocity and in thinking about accountability, this is actually a pretty important step. It may be anemic, but it could have been much more timid. I think that's taking Paul's word from this morning. It could have been much more timid, and it wasn't. And I think we need to acknowledge that.
Related question. What jurisdiction does the ICJ have over the perpetration of atrocities other than the Genocide Convention?
Well, if you read the case, very little, actually. I mean, we have had some of the sort of so-called aggression or cases, the oil platforms case or the armed activities on the Republic of the territory of the Congo. We've had some cases involving humanitarian law. But there's very little, if you look at this judgment, and this is just the majority opinion, right? Mm-hmm. It's not quite as bad as some of the cases, but it's huge. And virtually all the counts fall out completely because the only thing they had left in the case was the Genocide Convention, which is why the convention assumed this central importance, and all the other stuff, the ethnic cleansing, the crimes against humanity, just completely fell out of the case.
John?
Yeah, I think, if you have two states that have filed declarations under Article 36, you can have jurisdiction on that basis, but that doesn't happen very often. The human rights treaties presumably would cover situations where a state perpetrates genocide, but there you have very little submission to the International Court of Justice, and even in the treaties where you do find it, there have been reservations to it. In the Bosnia case, we did try a couple of others, and as Lila says, they fell away. The most serious one we had related to a 1919 minorities treaty. I mean, we were desperate for jurisdiction. We didn't care, all this discussion this morning about genocide and its importance. We didn't care whether what we were alleging against Yugoslavia was genocide, crimes against humanity, war crimes, or cream cheese. I mean, we just wanted jurisdiction. And the Genocide Convention was our last resort because of the difficulty of proving genocide, but it has Article 9 in it, and that gave a basis for jurisdiction. But we tried this 1919 treaty. Francis Boyle came up with the idea of using it. He asked me to write it. I wrote it. I wrote the argument 2 days before there was to be an oral hearing in August of '93 on that issue. Shabtai Rosen filed a very detailed response to our argument in which he went through every point and said that the 1919 treaty isn't in effect anymore. And of course, Shabtai Rosen is the expert on jurisdiction. He was also a major expert on the minority treaties. And we had about 24 hours to write an argument, which we were able to do only because I was in Columbus while the rest of the team was in The Hague. So while they were sleeping, I was in the law library writing it and faxing it to them, and that's what you see Professor Boyle presenting in the oral hearing. I think it was on the afternoon of the 26th of August. But I thought actually it was a solid argument. it was a bit convoluted because of all the steps. That treaty provided jurisdiction in the Permanent Court of International Justice at the instance of any state member of the League of Nations. And our argument was that that carried over to any state member of the UN. We lost on it on the grounds that what was being alleged took place outside the territory of Yugoslavia, and that the 1919 treaty applied only within the territory of Yugoslavia. Our counter-argument had been that was only because Bosnia had broken off, and these were the people that were supposed to be protected under the 1919 treaty. But the long and short of it is, as Lila says.
Mark?
I actually think the ICJ is going to acquire, looking ahead, a more important role in adjudicating matters that might be related to violations of international human rights law, international criminal law, and so forth. I mean, there's the armed activities in the DRC case, for example, that I think pushed the court in the direction of talking about unlawful use of force, didn't call it aggression, but looked at that, the Wall advisory opinion. And I think the docket of the ICJ is going to become increasingly populated with these sorts of cases. And I think that poses a big challenge for the ICJ, which, as you all know, about 2 decades ago, heard a handful of cases, highly symbolic in value in many regards, that didn't really deal with a lot of these sorts of complicated political issues. The question I would have for the judges on the ICJ and the ICJ as an institution is the following. Is this an institution that is at all ready for prime time? And I would have some hesitation in that particular front. And we can talk later about the question of evidence gathering, for example. It's a separate issue that obviously has been very controversial in this particular case involving Bosnia. But I think there's also a broader notion that in certain institutions, for example, if you look at the ad hoc tribunals, the judges in the tribunals have been pretty good at public outreach. They can be critiqued for it, but there's been some steps in this direction. And I think that judges see themselves, in certain regards, as members of a broader political debate on this particular issue. I don't see that with ICJ judges, and I just don't know if the institution is ready for judicial prime time.
Well, Mike?
Well, and if, on the initial question, I think I have nothing to add, but on that last point, I think if this was the ICJ's first attempt to sort of be a fact finder in the wide swath of an alleged genocide and so on and so forth, the track record's not good. So, and we can talk about that at greater length down the road.
Well,
That was going to be my point too. This reminds me a little bit of the Nuclear Weapons Advisory Opinion, which was so heavily critiqued because they did such a bad job with the facts. I mean, they just never wrestled with the facts, as the I guess dissent you would call it said, and I agree with the dissent here that the court really had an opportunity to step back and look at the pattern of atrocities and look at it in a much broader way that is A, fair to the accused in an individual case, or appropriate. In the individual cases, you've got to construe the statute narrowly. You've got to do it in favor of the accused. You can't do it in a way that the ICJ could have done it in a civil case. And the court completely basically says, well, yeah, there's a systematic pattern of atrocities, but we don't see any evidence of intent. And that just strikes me as completely implausible. The court completely failed, I think, on that.
Well, worse than that, it wasn't that we don't see evidence of intent. They set a standard for intent that was that your consistent pattern of conduct. You can infer intent from a consistent pattern of conduct if that's the only conclusion that can be drawn from that pattern of conduct. I mean, it's not an inference that is more persuasive. It's not an inference beyond a reasonable doubt. It's the only inference that can be drawn from the pattern of conduct, which, with respect,
go ahead, finish.
Impossible standard to meet.
Let me build on something that Mark suggested, and I think it's very important in terms of this entire discussion. How did the court decision in 2007 change the burden and standards for the proof of genocide, or did it?
My concern in this has to do most with American lawyers, specifically alien tort statute lawyers, who love to cite the ICJ as evidence of the law of nations. And I'm concerned that on several points, including the one we just mentioned, we've set the bar so high as to make it unmanageable. This is a point that was raised in an earlier panel, that this is getting turned over to the national level, not just at the criminal level, but also in the civil courts. So we have, number one, this impossible standard that's already been discussed. Number two, the court engages in what I'll call, or what is called, the fallacy of composition, where it divides up its discussion of genocide into 6 parts, corresponding to 6 different underlying acts that equal genocide. And then it divides each of those out into geographical sections. And for actus reus, that's fine. We have to find an underlying act to prove genocide somewhere in here. But then they continue that through, despite the fact that Bosnia was basing its entire specific intent argument on the pattern of conduct. They carry that through and in a single unsupported sentence toss out Bosnia's argument that a pattern of conduct can equal specific intent. And I worry, looking at the briefs that get submitted and have been submitted for alien tort claims here in the United States, that this is going to get cited all over the place in civil cases here, and that these two burdens, and don't even get me started about overall control versus effective control, are going to make it impossible for these people even to be civilly liable in states where such civil liability is available.
I just have one response. I think you're giving U.S. judges in Alien Tort Claims Act cases a high amount of credibility that they're going to sift through this hundreds of pages of judgment. But I think it's a valuable point. But I don't know if the problem is so much the law in this particular case as it just was a reluctance to go and dig in terms of the real facts. But I think there's also an interesting tension that is emerging, and that is between the work of the ICTY and the ICJ in a certain regard, right? I mean, it's not like the evidentiary record that went from one to the other was necessarily the most robust, but by the same token, it's also good, I think, for the ICTY to have the work that it did in the Srebrenica context to some extent validated. And I'm not being an apologist for the ICJ. I just said that I don't think it's fit for prime time, and I'm generally fairly conservative when it comes to the transformative power of law in any context when it comes to massive political violence. But, you know, this was a second major institution that condemned what happened at Srebrenica as genocide, and there is some expressive value to that. And I think we can critique the judgment, and we should, and the institution, and we should, but there is some modest expressive value to the condemnation of what happened at Srebrenica twice.
Right. Shall I go on?
Yeah, and in that context, the court does say that you can have genocide where population is being forced out. I mean, as the ICTY said in the Kristich case. And there had been an argument that goes back to the drafting history of the convention to the effect that if you're trying to force people out, that's inconsistent with genocide because you're not killing them. And there was a serious proposal to have that back in 1948, and it was rejected, and people cite that as saying, well, if you've got ethnic cleansing, then you don't have genocide. But the fact that they did say that there had been genocide at Srebrenica, even though Yugoslavia was not responsible for it, does mean that they are rejecting, I think, that approach.
Right. Little? You want final comment?
I think the case is generally a success for the ICTY, actually, because the court adopts pretty much lock, stock, and barrel everything the ICTY held, except for the two areas in which the ICTY went slightly further, right? So in the test for control, right, the ICTY actually says, well, we're not going to follow Nicaragua. We're going to have a more generous notion of whether or not Yugoslavia or FRY is sort of connected with what's going on in Bosnia in terms of internationalizing the conflict, right, in the Tadic case. So in that case, the ICJ just sort of, again, without really citation, says, oh, we're not going to follow that. We're following Nicaragua. And the other place is in the Kristich case, and I think this goes to something Elise said, the ICTY, as I read it, says you can, in fact, find complicity in genocide. You can find aiding and abetting without showing specific intent. Now, Brigitte Stern says that this court didn't say anything about complicity requiring specific intent. I don't think there's any way to read this opinion without concluding that, in fact, what the court said was you can't have complicity in genocide without showing specific intent. I think that's what was really being required to show in order to find Serbia liable. And since it wasn't demonstrated, the court says no responsibility for complicity. So I think in the two areas where the ICTY arguably expanded slightly the notion, the court rejected that. So it's a highly cautious, very conservative opinion, even more so than the tribunal.
Just in response to that, though, is it really that surprising that the ICJ followed its, I mean, I know there's no stare decisis, but is it that surprising it followed its own precedent, right, as opposed to the ICTY's? We could read it a different way, right? So I don't know. I don't know if that surprises me.
But the precedent in question, the Nicaragua case, is so easily distinguished that it took one paragraph in the main dissent to knock it out, namely that the nature of the shared intent between the United States and the Contras was materially different and was an appropriate place for a more narrow effective control test than the nature of the shared intent in this case, which was a shared intent as to the criminal acts. And in such case, you don't need to show effective control. So, I mean, not surprising. I mean, I agree, but it didn't have to go that way. You know, it's not as though it was on all fours.
A couple of you have already alluded to this, but let me ask it more directly so that you can clarify your points. What is the interplay between the International Court of Justice and the other international criminal tribunals with respect to the atrocities in Yugoslavia? I think, Leila, you alluded to that, but is there a way to specifically link them together?
Well, you know, here's the question, really, that we didn't get an answer to in this case, which is, can you have a finding of genocide, or if we had a Crimes Against Humanity treaty, right, could you have a finding of a crime against humanity? Could you have a finding of war crimes in a situation where you wouldn't find criminal culpability, but you would in a civil case? Because presumably in a state responsibility case, you would have a lower burden of proof. Now, that wasn't true here. They came up with this fully conclusive evidence standard. The Inter-American Court uses clear and convincing evidence, which would, you know, be more than balance of probabilities, but less than this fully conclusive. I think the ICJ really could take a very different role. And I know that sometimes that upsets us in international law because we want it all to be completely coherent. And how can you have universal jurisdiction crimes with different definitions? Well, look, France has a different definition of genocide than the Genocide Convention does. And we accept that as part of having different jurisdictions. France included social and political groups in its convention definition. So it's kind of nice in that I guess we have sort of a unified theory here, but I do feel that the court maybe could have taken a stronger, could have gone out there a little bit more,
right,
been more expansive. It's a missed opportunity.
Okay. Anyone else? I have another question.
Kind of a historical footnote on that. If you recall back at the end of World War I, when the permanent court was being set up, it was argued by many that it should have criminal jurisdiction. That is, that both would go into the same court. Had that been done, I don't know how all this would come out. They'd have to have different standards approved for it.
Right. Okay.
Well, I think the judgment in this case makes it clear that what they intend is that that is possible, but it's practically impossible. Scott McDuff's declaration makes it clear that he doesn't think so at all. He believes that genocide, that the ICJ has no business engaging in a finding of individual genocide, and that it must refer to a prior finding by someone, by the ICTY or some other court of appropriate jurisdiction of genocide, and then it can address the state responsibility issues. So,
three-part question. This was prompted by some discussions earlier this morning, and Paul Williams alluded to it earlier when he mentioned, he advertised my panel. I appreciate that. Three parts. First, is ethnic cleansing genocide? Part two, when does genocide begin? Part three, when does genocide end as a crime?
What order do we take this?
Well,
I take the last
whichever one of you wants to go first. The courageous one.
I'll go first, and I'll take the last one. I think one of the things we learned from this is that responsibility under the Genocide Convention continues until you've turned over the last man to a court of appropriate jurisdiction. I mean, despite not finding on most of the claims by Bosnia in favor of Bosnia, they did find on the failure to try or prosecute and the failure to cooperate with the ICTY with respect to Mladic.
When does genocide begin?
I think it can begin rather early. I mean, I think the whole idea of the Genocide Convention was to nip it in the bud, to define the act in such a way that you could prosecute someone who was beginning on a process that would lead to mass killing, even though it hadn't yet led to mass killing. And in that sense, I think it differs from crime against humanity. So all this discussion that we were having, especially in the defense panel, about genocide being the worst crime, that doesn't, to me, come out of the definitions of crime against humanity and genocide as you see them written down. I think the court, the ICJ, is probably in a better position to deal with an incipient case of genocide. That's what we were trying to do in 1993 by suing Yugoslavia. I was interested in Ms. Jung's comments earlier about investigating for the ICC as a way of deterrence, because generally the criminal prosecution comes fairly long after the fact. I mean, especially now we see in Cambodia where if there are prosecutions and convictions, the prisons will have to deal with geriatric care. I mean, I really see the Genocide Convention nowadays as most important in the state-to-state context, despite the limitations that the court has put on it here in 2007, because there is jurisdiction. With respect to criminal prosecution, I don't see it as a very important thing anymore. You have in the domestic realm, you can always prosecute for murder. There's no need to prosecute for genocide and it's done for political reasons only. In the international realm, you can prosecute for crime against humanity. There's no need for genocide. But in the state-to-state context, I think it has some significance.
Mark?
I think one interesting question isn't just when does it begin or when does it end, but it's this entire notion of how do you punish, right, under the Genocide Convention, which obviously is mandated. And one thing we haven't yet talked about that I think is important, and I totally agree with Layla, the idea of concurrent judicialization, many different kinds of dispute resolution entities, whether criminal courts, state sort of civil institutions like the ICJ, local or national proceedings dealing with this kind of violence is good. But the question that I would have then in terms of punishment is the following, and it would be one of distributive justice, right? So let's say that damages would have been awarded. Let's just say it would have gone to levying some kind of, financial damages against Serbia as a whole. I mean, I think that gives rise to a series of distributive fairness questions, right? Because inevitably damages against the state as the whole are going to be passed through to the individual citizens of that particular country, not all of whom are equally culpable, some of whom may actually have resisted. I just don't know how you calculate out the actual operationalization of punishment as envisaged by civil claims over which the ICJ may have jurisdiction. And to me, it's almost a bit of a disappointment that there was no damage award, because I think that took it just took the hat off the table in terms of not having what I think would be a very constructive conversation about how you individualize responsibility, civil responsibility, in a criminal state or in a state that was found to have violated this particular treaty, convention. So I think that in terms of, it's not just when does genocide begin or when does it end, but who's responsible for it. And unfortunately, in my mind, the ICJ didn't really hit that question by just focusing on, Bosnia, this declaration suffices, right? And I don't know. I mean, because that really poses a major challenge to the entire idea that more judicialization is good. It could very well be, and if you talk to someone like Richard Falk has circulated a very interesting paper on this, where he styles it lawyer's justice versus justice. And in a sense, maybe we all have to believe in the fiction, right, that Serbia doesn't actually have to pony anything up on the table in order for it to move beyond the level of violence that was committed in the name of Serbia, or else the oppressor state is simply too stigmatized ever to move on. I don't know. I mean, those are very difficult questions.
But Serbia is not stigmatized in the eyes of the United States or the United Nations. They've been accepted.
Yeah. Chris, I wanted to go to this question of ethnic cleansing because if you look at the Krstić case, there's a very interesting partial dissent by Shahabuddin, right, where he talks about the ethnic cleansing, and he would have argued to have it be criminal. And I can see why the majority would say no. In a criminal case, this would be an expansion of the statute, which may not be appropriate in a criminal case because you want to read the statute in favor of the accused, because of the legality principle, the rights of the accused, etc. But now moving over to this civil case, the ICJ basically just said the same thing. I mean, I know they leave it possible that ethnic cleansing can be a crime, but the way I read the opinion, they basically say what happened in the former Yugoslavia, the ethnic cleansing, was not, period, genocide. That's how because Srebrenica, you really have mass murder. You don't just have the ethnic cleansing. So here you have a situation, and you have leaders and their followers, and they determine that we're going to push an entire population out of a territory, and to accomplish this, we're going to kill thousands of men and boys. Okay, that's Srebrenica, but there were lots of other things that happened. Bust out thousands of women and children, torture, rape, destruction of mosques, destruction of lots and lots of crimes. I mean, in a death toll of, 100,000, a couple 100,000 overall. And to conclude that, for the ICJ not to step back and look at that pattern and say that in some cases ethnic cleansing amounts to imposing, to use the convention language, conduct calculated to bring about the destruction of the group. It strikes me that that at least should have been much more seriously discussed in the opinion, because it was pretty bad, right? It was a pretty horrific war in terms of scale and in scope and the nature and the intensity of the atrocities. And the ICJ gets very short shrift. It's just sort of following the ICTY, but it's completely inappropriate, in my view, for it to have just followed the ICTY without really considering whether that couldn't be an interpretation of the convention.
Well, let me make one interruptive comment. This is not to criticize you, Layla, but it's very interesting to me. Sharif Bassioni once pointed this out to me, that we tend to talk in hundreds of thousands or 1.8 million victims, and we pass over it. You find a family of 5 murdered in Cleveland, and it becomes major news and major concern, not just in Cleveland, but nationally. And yet, when you start speaking in these large numbers, we lose track of the fact that these are all human beings. They're all being murdered, and the reason they're called genocide is because they're being murdered for a specific reason, and it shouldn't be dismissed. It's very easy to look at numbers and just not let them register, but I think it's profound for all of us to realize that we're talking about human beings being murdered for who they are and not what they've done. We're going to do questions in a moment.
But on the point, though, of genocide, I mean, if you look, for example, at genocide scholars, for example, and there is this community out there, it's quite interdisciplinary, that works in this area, there are a lot of purists in that community that believe that the extension of the term genocide to what happened at Srebrenica is a very activist interpretation of that particular crime. And we can quibble about that, might make us uncomfortable or might be too much legalese, but I think there was a very vivid debate even whether the finding of genocide at Srebrenica was factually justified in terms of the application of the law at the time. Now, it's happened, so there's judicial notice, and I've just said there's expressive value to that. But, you know, there is a community out there that thinks the term genocide, if it's truly to be the crime of all crimes, is only to be applied in extremely rare circumstances. And you may come back and say, well, there's really only been sort of 3 judicialized genocides, and you're right, but I don't know. I mean, I think we need to recognize the fact that there is pushback even. I mean, Bill wrote an article on Srebrenica, on the early decisions that began to debate whether or not there was genocide there. And it's an open area for debate legally. And not just fastidiously, I think genuinely.
Sure.
I think one of the ways in which the ICJ followed the ICTY was to say that that it hadn't used genocide. That was one of its bases for saying that all what happened in '92 and '93 was not genocide. And that, I mean, some of the dissenters just ripped the court apart. I mean, it's a ridiculous position that the court's taking there for a couple of reasons. I mean, one, there had been the indictment for Mladic and Karadzic on genocide. There had, in fact, been a conviction of a man named Jelicic, at least at the, well, not at the trial level, but the appeals chamber said that he should have been convicted of genocide, even though that one was a questionable one in terms of the facts of the case. But they also talk about plea bargaining. They say, well, the prosecutor in some cases charged genocide and then dropped it. That means that there wasn't genocide. I mean, that's just, you know, how
that was alluded to earlier.
I mean, that's a decision of a prosecutor in a particular case to handle it a particular way.
Anyone else? Does the ICJ decision in this case underscore the limited utility of the Genocide Convention? We've talked about problems with the ICJ in dealing with the crime of genocide. Does this also indicate that the Genocide Convention has only limited utility?
Wow. Well, maybe I'll tie that into something Mark said. You know, to me, the Genocide Convention is a monument to the Holocaust. That's what it is to me. And it very much codifies the horror. I mean, Lemkin ran around saying we have a crime with no name. Here we want to, you know, we want to name it. And so to me, I think Mark is right that there's this sort of tendency to want to restrict it, right? Because that was the crime of crimes. And there was this psychic shock that came out of the Holocaust. I would say for it to have much utility, I would want to divorce it a little bit from that sort of normative crime of crimes language, which, as many of you heard my intervention before, I think that's an unfortunate terminology, even though I have Bill Shavis looking right at me, so I'm getting very nervous. But I think that's a really unfortunate terminology because I've been doing a little research on this, and if you take the sort of 120 million odd victims, civilian victims that have died in conflicts during since World War II, and I have a list of them here actually, probably only 2 million can be covered by the Genocide Convention, and that leaves about 118 million people killed, many of whom were tortured or maimed or
Killed by their own governments.
Killed by their own governments or in conflicts, including Cambodia and other conflicts, and it's just a horrific list, right, that aren't covered by the convention. So I think whether it's the crime of crimes or not, I think it's an unfortunate terminology. If we give it just its legal characterization, that is, it's a particular kind of crime against humanity in which the perpetrator intends, with a specific intent, to get at a group through killing or other destruction of individuals, then fine. It's like a hate crime in the United States, that it's a particularly pernicious form of murder or a particularly pernicious form of torture. But I think the really relevant crime is the crime against humanity, and one that isn't codified other than in the Rome Statute. There's no ICJ jurisdiction. And so we sort of, you know, the elephant in the room is the thing we're ignoring, which is the other 118 million victims.
Right.
So for me, yes, genocide scholars may say it's terrible that we expanded the definition, but I think we're looking for some way to provide accountability for the victims of human rights atrocities, and the convention is not helping very much.
John?
Yeah, I think if we did have a convention on crimes against humanity with submission to the International Court of Justice, we could stop talking about the fine points and the meaning of the Genocide Convention. I felt, as an advocate for Bosnia, that I needed to push it a bit to try to get it before the court, because we had no idea whether the court was going to say that what was going on in '92 and '93 constituted genocide. We did get the two orders. Those orders were read, I think, by at least one of the judges as more or less a finding that genocide was occurring. The fact that the court issued not one but two interim orders again further suggested that it thought that this probably was. But I think we'd be much better off if we had some other jurisdictional base.
I mean, I guess I just have 2 quick points in response. Sure, we can all sit around and say, oh yeah, it should have been really, harshly enforced, enormous damage awards. blah, 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 blah. But I think one response to that would be the simple reality of over-legalization. States would just withdraw right from this regime, and it would end up losing some effect. And I want to make a second point, maybe we can talk about a little bit more later on, that I think is interesting, and that's to connect our discussion here with this discussion earlier this morning on Melissa Waters' panel. And that is, what's the relationship? So we have the ICJ finding a state responsible for failing to prevent genocide. Okay. So what's the relationship between that and more broad duties to prevent, responsibility to protect, and so forth? What is the connection there, right? So what would the implications then be for a state that was outside of the place where the genocide that was occurring, but no one bothered to intervene? So let's assume, for example, there's genocide in, just work with me here. So assume there's genocide in Darfur, and assume that there were jurisdiction, and assume then that this judgment might open up a space for some sort of responsibility or liability for other states that may do nothing in that particular context. And if that is an assumption we're willing to work with, then I do think we run into the risk of a certain degree of over-legalization and a chilling effect if there had been firm damage awards, right? So I just think that that's something we might want to play with a bit.
And I found it interesting on that panel or another panel that Mike Newton in particular referred in certain contexts to the right to protect, and then in other contexts to the responsibility to protect. One creating a space for states to exercise discretion or the Security Council to exercise discretion, and the other creating an affirmative and possibly actionable obligation.
But in the 2007 judgment, the court, in discussing whether Yugoslavia had failed in its obligation to prevent, stressed very heavily the connections between Yugoslavia and the Bosnian Serb militia. To go from there to saying that Uruguay has committed an international delict for failing to intervene in Darfur, that's a bit of a leap to me.
Well, I know it's a leap, but this is the first time this kind of a judgment has come down in this particular issue, and I think it ought to inform a broader conversation.
Well, maybe it's not Uruguay in Darfur, but maybe it could be France and Rwanda in '94, right? So, or other United States and Rwanda in '94. So I think Mark's point is well taken, but the difficulty is, so if you say, well, we're not going to over-legalize because we're going to scare states away, and they're not going to ratify these treaties because they're going to worry about liability, either way, we're stuck with states not having any responsibility to do anything. So I suppose it cuts kind of both ways, doesn't it?
We're running short of time for this roundtable discussion. Let me just make one quick comment, just an observation, then I have one final question. The observation is that I've heard both Bill Clinton and Madeleine Albright say, in response to a question, do you have any major regrets in your life? Both of them said the failure to act in Rwanda. And they've said that publicly as well as privately. So, it seems to weigh deeply on their conscience that they allowed 800,000 people to be murdered in 100 days and did nothing. And I think that is some cause for concern. Why? Why did they not act? The final question sort of ties this whole panel together, and then I want to open it up to a dialogue with you, the audience. The final question is, what lessons can be learned from the ICJ decision and its treatment of genocide as an international crime? We talked a lot about the case, we talked a lot about the notion of genocide today. What lessons can be learned from this specific case and the ICJ's treatment of genocide as an international crime, perhaps in the future, perhaps for jurists in the future?
Bill Chavis already said, if it's going to be genocide, it better be before the ICC. That's number one. That's the easy one.
Some faint hope that's left open. One is that there is an erga omnes principle that applies here. That is, I think in principle it's possible for any state that's a party to the Genocide Convention to bring an action against another state. Now, they usually don't do it. So that's why I say it's a slim hope. The other comes out of the decision of the court in the DR Congo case versus Rwanda with respect to reservations to the Genocide Convention, where a number of judges on the court are now questioning the validity of a reservation to Article 9. Article 9 was mentioned this morning by Henry King as the submissions clause, and to date, the court has honored a reservation to Article 9. For example, in Yugoslavia's case against the NATO countries, when Spain and the United States had reservations, the court said, okay, they're out. But the judges now seem to be questioning that. They seem to be going along the line of saying that it's inconsistent with the object and purpose of the Genocide Convention to file a reservation.
Mark? Yeah.
One lesson I would say is the same lesson I would apply to all international judicial institutions, namely, we need to have much more modest expectations of what international legal institutions can do in the face of depraved human evil, and we've got to stop overselling the product, we've got to stop over-marketing the product, and just recognize that law can do something, but very, very modest something, and recognize that we're taking very, very small steps here.
It's not a panacea for human rights protections or justice.
I think the lesson is if you've got an active criminal tribunal, you might get some traction in a civil case, but otherwise you're unlikely to get much of anything.
Michael?
And then to go to a harder one, one lesson for the defense bar is if your client is going to commit genocide anyway, shred any documents proving specific intent, because Serbia was able to do this with no ill effect, with no what we would call burden shifting. And if you are in the ICTY, if you are in the ICTR, if there's anything the judgment teaches us, and without meaning to be glib, you need to charge genocide more often, because the ICJ drew, I think improperly, as we've mentioned, a lot of conclusions from the lack of convictions and the lack of prosecutions for genocide. So this indicated to it that it could infer that the ICTY, Office of the Prosecutor, and the tribunal did not think there was genocide. So lessons for both sides of the tribunals.
The Serbian government learned well from the experience of the Nazis at Nuremberg, that if you leave documentation, it may be used against you. All right, we have about 12 minutes or so for questions. Sir, you had a question during the course of the discussion.
I was just going to quote Joseph Stalin. Joseph Stalin is reputed to have said that if you kill one person, it's murder, but if you kill a million, it's only a statistic.
That's right.
His morals were pretty low, and his knowledge of the law may have been off, but his understanding of human nature appears to have been entirely too accurate.
I agree with you. Sir?
Well, I'm just wondering, I mean, maybe I've missed something in the overlap, but I mean, just linked with the last session and linked with the Krajisnik case. There was a case, after all, that was it, where the ICTY did prosecute for genocide, and, you know, if after a 2.5-year trial they didn't get a conviction, on what basis? Sorry, I thought I was understanding panelists to be suggesting that the finding that there was no genocide was objectionable. I mean, if the ICTY, if the OTP couldn't establish genocide in Bosnia during that period over 2.5 years of a criminal trial, how else was it established? I mean, who else committed genocide? If Krajisnik didn't, then who did commit genocide then?
My chief objection is the methodology the court used, by which I don't think the ICJ could ever, as a practical matter, find genocide. Namely, we're going to drill down to the local level and to each element, and we are going to miss the forest for the trees. Now, is there now?
I agree with that problem, but that problem didn't arise in the Krajisnik case. I mean, the OTP had the opportunity and did in fact link together the whole thing. And when you talk about the killings, they, as the ICTY trial chamber made clear, they can only go on the basis of the killings that are actually proved by the evidence in the case. And I think what you're saying about the mechanisms, I mean, it reminds me, I've done these Turkey cases in front of the Strasbourg court where, I mean, they dealt quite well with that really rather difficult problem of finding facts. but it just shows how very difficult it is. I mean,
But the ICTY has a very different job, right? I mean, I would be very critical of many of the ICTY cases too, but the ICTY, it seems to me, if you look at Yelicic, where they acquitted actually, Stakic, where you look at all the cases in which the ICTY says no genocide. Even in Yelicic, you know, this guy's calling him the Serb Adolf, right? I mean, but in all of these cases, they're saying, it's almost as if there's a two-part inquiry, the way I look at it from behind. They sort of say, was genocide committed, and then did this person have the specific intent? That's how I'm sort of seeing a lot of these cases go on. And that preliminary conversation about was genocide committed, I think has, in part, a political dimension to it. In Rwanda, everybody immediately said, this is genocide. It's Hutu, Tutsi, two different groups. I've heard commentator after commentator stand up and pound the table and say there have only been two genocides, Rwanda and the Holocaust. And you'll hear this systematically. In Yugoslavia, it was very confusing.
sorry, but if no individual commits genocide,
well,
there is no genocide.
Depending
Right.
on your view of joint criminal enterprise or accomplice liability, can't we very easily construct a hypothetical situation where a group of people, none of whom under the statute of the ICTY and under the definitions and elements of crimes of the ICTY, committed enough of the acts and were sufficiently complicit to be individually convicted beyond a reasonable doubt, so on and so forth. But when you look at, which the ICJ should have done, and this is my objection, when you look at the entire enterprise, you've got a genocide.
I have great difficulty with that. A great difficulty with the idea of there being no human being being guilty criminally of genocide, and yet genocide having been committed. I mean, that seems to me to be.
Well, some of the human beings have died. Right?
Well, oh yes, obviously. If you, yes, I mean, I agree with that because that's no different. I mean, if you, in principle, that's somebody who would have been convicted if he had been tried. But if you say that there's no human being who can be convicted, and there's no dead human being who could have been convicted, how could there be genocide? I mean, genocide can only be committed by human beings if nobody is criminally liable for genocide. There just was no genocide. Isn't that right?
Well, there are two separate issues. One, there was no doubt that if you look, even the ICJ admits that Muslims were being targeted, right? That there was a group that was actually being targeted.
It's persecution and extermination. I mean, Srebrenica certainly was both of those things, you know, whatever you...
But the question, which I think is the more interesting question, right? You have a treaty between states that says you need to criminalize this offense. And then it defines the offense in pretty vague terms. And one of the elements of the offense is this intent to destroy in whole or in part, right, the part of the group. And so the question is, what does this treaty mean as a question of state responsibility as between states, as opposed to what does it mean when you operationalize it, to use Elise's term, and look at criminal culpability. At least in our legal system, all the time we use statute. This is sort of the flip side of Nuremberg, right? At Nuremberg, they took treaties between states like Calabrian and other treaties, and they turned them into criminal statutes. Here you have a treaty between states that says create some crimes, and now take those crimes to the individual level. And here that Bosnia was trying to use the treaty very differently. Now, I'm not saying how the court necessarily should have come out on it, but it doesn't even address the pretty profound questions, I think, that were involved in the case.
But I do think Richard has a point, which is that it is not altogether uncontested whether or not, you know, there's been judicial notice of genocide at Srebrenica. We can all agree on that. I think the point is that was not without some controversy in terms of being a conclusion.
That's
so
true.
Consequently, I think the ICJ judgment and disappointment registered with it needs to be layered on the fact that the historical record wasn't altogether clear-cut to start off with, even though as international lawyers we all accept, and I do, that genocide has occurred at Srebrenica.
Bill?
I'm glad Nick made those comments because
This is like Phil Donahue.
this is called a roundtable.
Oh, that's Nick.
It's a bit lopsided. I'm not sure if that's the right metaphor. Here we see Rosalind Higgins, the president of the court. We have some of the greatest jurists in international law in the world who come to a conclusion, and our roundtable all disagrees and thinks that they got it all wrong. I guess I've indicated my view already. I think the judgment is actually fairly solid and was quite predictable. what the court has done is drawn a bright line between, and this is really the core of it, between genocide and ethnic cleansing. Now, there were many who hoped that it would lean the other way, that it would tilt further towards ethnic cleansing and encompass more of it into the definition of genocide, and it simply said, no, we're not going to do that. That wasn't unpredictable. It wasn't, by the way, based on a lightweight assessment of the facts, because the court, as Nick has pointed out, relied on, no question has been more exhaustively addressed in the trials of the International Criminal Tribunal for the former Yugoslavia in Stakic, Brjanin, Krasnik, Sikirica, Jelicic, all acquittals, all acquittals. There were a lot of judges who thought about this at the Yugoslavia Tribunal, many of them. They heard a lot of facts, and they all said, it's not genocide. Except this one exception, which is a bit anomalous, really, and that's the problem, is that some of the judges, in an attempt at compromise, said, well, okay, we'll call Srebrenica a genocide. And they're still dealing with that. They had 2 convictions of aiding and abetting in genocide at Srebrenica, no conviction yet of genocide, and they just acquitted one of them, General Blagojevic, on appeal, got acquitted. He's the general working with Krstic, but he doesn't know about the plan. You know, it doesn't really add up to very much, finally. And so the International Court of Justice, on the legal side of it, not only is it ICTY, it's the Darfur Report, which takes a narrow view of genocide. It's the fact, remember this at the Rome Statute, people have talked about enlarging the definition of genocide. But when they had a chance in 1998 at the Rome Conference, they say, don't touch it. Leave it the way it was in 1948. So I think all of this, look, people are disappointed sometimes when judgments don't develop the law, but they just said that's where it is, and it was predictable. I think it's unfortunate that the Bosnians who suffered so much ended up so poorly in the result, but maybe that's the fault of their lawyers. I think if I'd been a lawyer for Bosnia, I could have got the Serbs to settle a year or 2 ago by going to them and saying, how about this? You confess to crimes against humanity, you apologize, you give them some money, you build them some monuments, a museum, etc., and we'll drop the case. They might have had something very attractive, but they stubbornly stayed with it because they wanted that, the great prize, the cherry on the sundae, call it a genocide.
But is that...
One last comment, Chris, because I know I feel that because the Roundtable was a bit around.
skewed.
It's not but I'll just make one last comment. It's a bit about the evidence. So much has been made, and Michael was referring to this about how, they destroyed the evidence, or people said the Serbs didn't give up all the evidence. I think that's a fake argument, because once you decide that what the Bosnian Serbs did wasn't genocide, it doesn't matter how much Belgrade controlled them. You could have evidence showing that Milosevic ordered every single thing that happened up until Krstic on the 13th of July 1995 improvised the genocide. But if all that evidence showed, and I've discussed this with people at ICTY, I discussed it with counsel for Bosnia in the case. I had lunch with Tom Frank last week. We chatted about this. If all it shows is that Serbia was in fact controlling what the Bosnian Serbs did, if they didn't commit genocide, you're not advanced one iota.
Bill, you found me out. Now you know why I entitled this a conversation as opposed to a roundtable. We're out of time, and I would like to thank our panel, Mark, Michael, John, and Layla, for what I think was a very rich conversation, very provocative. To the extent that we had a dialogue with the audience, it was more of a crossfire. But that's okay. And again, I want to reiterate my great appreciation to Michael Scharf and his organizers for what I think was a very productive and very valuable meeting. Michael?
Thank you. Thank you very much, Chris, and thank you, panel. Please stay here. I'm just going to do very brief closing remarks and get us out of here at 6 o'clock. But to do that, Brianne has to, she has. Okay. Let me start by telling you about something really new and exciting that just launched today during our conference. Behind me is live the new and improved and expanded Groshen Moment website. It's a little squished because of this particular computer. If you have a bigger computer at home, it looks a little bit better. Anyway, what's new about this is instead of the old Groshen Moment, which was the Saddam Hussein trial, this is now an expanded Groshen Moment that deals with all of the major ongoing war crimes trials, and you see a little Pol Pot. I know he's not there anymore, but he symbolizes the Cambodia trials. You've got Saddam, who's no longer there, but he's symbolizing also the continuing Iraqi High Tribunal trials. And Charles Taylor is still there, and he's symbolizing his trial, which will start up again in January. If you would go to the left, Brianne, and just log down, the three different blogs are in the left with the three different faces over there. And if you'll go to the Khmer Rouge genocide trial, yeah. Okay, so we have our very first, posting that occurred during the day while we were having our conference. Who is this? John Hall posted this. It's something I know. It's something that he had derived from something that he wrote for the Wall Street Journal, an extraordinarily provocative piece. So I preceded this with a little editorial note, which you'll read there. It says, this is the inaugural essay for the Grosjean Moment Cambodia Genocide Trial blog. Our panel includes experts like Professor John Hall, who are highly critical of the Cambodia Tribunal, and, importantly, those who support the project, believing things are progressing as well as could be expected in light of the many challenges. It is our hope that this initial essay, which we know is provocative, will launch a spirited debate both among our Grosjean Moment bloggers and the public at large to appear in the coming days and months on the website. Now, the key here is that many of the people who made the Grosjean Moment website so famous, it won many Blog of the Year awards. It was the highest ranked international law blog last year in the Weblog Award category, and it's been cited and it's been visited about 2,000 times a day. They're here in the room. And toward the end of the Iraqi tribunal, I think a lot of us got, I don't know, tired. Some of us, I think, maybe were demoralized by the way things went. So we stopped blogging. This is to relaunch us. And I hope I can count on you who were bloggers before and also a new group of bloggers. So all the people who were at this conference and also anybody out there in the audience who's interested in starting a dialogue and a debate on these issues. So we start, yes, with a provocative thing, and yes, I know that particular essay doesn't make you happy, Robert, but we promise you there will be responses to it, and that was the intent. Okay, so will you then just switch to the last slide? That's all I want to say about that exciting project, and I do hope we can count on you to participate in that. Some final thoughts about the conference. Brain drain. The term usually is something that you think of in immigration of elites from a country. I think it also can describe how many of us feel after a day so full of insights and provocative debate. To memorialize these insights and the debate, we will be publishing a really special thick double issue of the Journal of International Law, similar to the ones we've done in the last couple of years. And we hope that this conference and the upcoming publication will progress the understanding of the Genocide Convention and improve its effectiveness, if that's possible. I really, really need all of the people who came here to speak, who promised to participate in this, to actually get us their submissions by November 1st. So you're on the line here. You've publicly signed up for that. Let me say that I was born just 17 years after Nuremberg. But when I grew up, it was ancient history. And I grew up during the Cold War, and it was an era when it was really an era of impunity. You quoted Stalin about 1 million people as a statistic. The Cold War was all about that. A person had a much greater chance of being prosecuted for killing one person or 5 people in Cleveland, as Chris said, than killing 1,000, 10,000, 100,000 people. And all over the world, people were getting away with genocide-like crimes. Stalin, Mao, Pol Pot, Idi Amin, smaller crimes like the Duvaliers and Pinochet, and nobody was doing anything about accountability. Well, my son Garrett, who is 12, was born when the first international tribunal since World War II, the Yugoslavia Tribunal, was just getting up off the ground. He's growing up in a new era of accountability. And we see now this whole proliferation of these international tribunals, the hybrid tribunals, the nationalized tribunals, and even domestic national tribunals prosecuting their former leaders, like Fujimori, who's about to face justice in Argentina. Well, we owe this change in large part to the people who were here today. It was really an extraordinary crowd of experts. The prosecutors at Nuremberg, Henry and Ben. I didn't know when we picked September 28th that that was the date that 60 years ago Ben Ferencz gave the first speech before an international tribunal that used the word genocide. And we were there to see that. And we'll never have a conference like that with that kind of timing again. I don't know if we'll see Nuremberg prosecutors all together again like that panel. Also, the prosecutors, the defense counsel, the judges of the modern international tribunals. And yes, I include defense counsel because they are so important to the success of the endeavor. And also the government officials, former government officials who we've had here, and especially the academics who are helping make sense of all of this and feeding the precedents to the international tribunals and to their advocates and to the world. Those people who spoke today are the ones that are responsible for this change, and it's really a positive development. We can't stamp out genocide, but we're finally, after really 50 years of doing nothing, we're finally fighting it. Our next event at Case Western Reserve University, sponsored by the Cox Center, is in 2 weeks. The Chief Prosecutor of the International Criminal Court, Luis Moreno Ocampo, will be presenting the Cox Center's endowed lecture at 4:30 p.m. on October 16th. I know a lot of you aren't going to make the trip all the way over for that, but you can join us live or by the webcast. And now, please join the speakers for a reception in the rotunda behind us, and thank you all for a wonderful day.